page of the Sunday Times today has news of a new law that's coming in about, this is all in the area of how cases are prosecuted against sex offenders. One example of which is alleged rape victims will no longer face cross-examination live in court, thanks to reforms announced by Elizabeth Truss. Liz Truss, the Justice Secretary. From September, victims will be able to give evidence in a pre-recorded video that we play to the jury once the trial begins. So, alleged rape victims will not have to face cross-examination live in court. They will be able to pre-record their cross-examination, and thus the intention is reduce the trauma to them. Well, to see if this is a good thing, I'm joined by the director of Mary Monson Solicitors on Fleet Street, Joseph Kotrie-Monson. Joseph, how are you?
Good afternoon, Stig. Doing great.
On the face of it, this seems like a good idea, doesn't it? Because one of the presumably most abhorrent things that can happen to a rape victim is having to relive her experience in a court where someone is staring directly at her who may have raped her.
I think that's right. I think there's a great deal of good intention behind this. In fact, this has been lying on the statute book since 1999 without being enacted. Of course, courts should be looking at making the process of giving evidence if you've suffered something traumatic easier, certainly engaging with it in a sensitive way. The current situation, of course, is that in most sexual cases anyway, the complainant gives evidence for the prosecution in a pre-recorded video months before the trial anyway, and the evidence that they then give under cross-examination, you'll know, of course, Stig, that's when the accused person's lawyer wants to ask that person questions in front of the jury. Well, that happens on a video link outside the courtroom anyway. Yeah. So we're probably not talking about anything that revolutionary in terms of making their experience easier, because that cross-examination, they already don't have to set foot inside the courtroom, and there's a great deal of protocol about the types of questions that can be asked and ground rules hearing beforehand. What's being suggested now is that all of their evidence, including the cross-examination, as you've rightly said, takes place before the trial is recorded. And I think that has difficulties in practice, which has probably meant that all those successive Justice Secretaries since 1999 have steered clear of enacting it. The problem is that, Stig, the defence can't cross-examine until the police and the CPS have disclosed all the information that the state holds, and any other organisations, state agencies, social services, etc., that may assist the defence, so that they have a fair trial, because the trial is about fairness and about getting to the truth primarily, and that doesn't usually happen until the days leading up to the trial or the trial itself.
So the risk here is that, of course, we talk about alleged rape victims. There will be many occasions when the defendant is not guilty, subsequently not to be found guilty, and one has to have regard to the fairness of the process for that person, just as for the fairness of the alleged victim.
That's right, Stig, and I think there's a wider argument that perhaps even though more can be done in terms of making sure that courts are more friendly and more accessible and more sensitive, that the pendulum is swinging in a little bit of an erratic way here. Every time we focus on making things simply easier for complainants without thinking about whether the changes impact fairness, I think we probably inch closer to unwittingly losing sight of the primary goal of a trial, which is to get to the truth. And whether you like, whether we all abhor the rapists, but if you want an accurate, if you want a consistent, and if you want a just justice system, it means that through gritted teeth, the defence should be treated equally until the verdict. And that probably isn't happening already. Vulnerable or young defendants and their witnesses, no matter how vulnerable they are, they do not get any of these types of protections in court. If the goal is achieving the most reliable evidence, I think what's good for the goose should probably be good for the gander.
It's an interesting point. That's Joseph Kotrie-Monson, director of Mary Monson Solicitors on Fleet Street. It's a fascinating case.